podcast today. My name is Harley, and with me is Jason.
Hi.
And Manfred.
Hello.
Hello. Now today we're talking about issues pertaining to our essay, and we all wrote on the essay, is law powerless against the profit motive of companies? Now this is a bit of a paradoxical question because companies are a legal construct, so the idea that law does not have the power to regulate its own baby might seem a tad ironic to some persons. We'll start by looking at some questions that proceed from one another as the guide of our conversation. So, firstly, we ask, who does the law serve? The public or private interests? Now, for background, we suggest that private interests means serving interests of big business, such as corporations, and public interests more broadly means just serving the interests of the citizens of the nation. Now, for my answer, I would say that, in my opinion, since the 80s, neoliberalism, which is a general term to define the sort of global corporate-centric intellectual, economic and political paradigm, has become entrenched across the globe, everywhere basically except for North Korea. And the effects of this has been to whittle away the political and economic effects from before then through means of privatisation, deregulation of finance, labour markets, gutting the power of unions, and this has essentially led to wealth redistribution to the upper crust. Effectively, this means that the government has retreated from public ownership and having a meaningful role in the economy. That's my opinion, and law has facilitated this by implementing a pro-business regulatory regime. Now, what do you think, Jason, about who the law serves, whether it's public or private interests?
I think when considering a pro-business regime and looking at the private and against the public interest, it's important to consider the public's interest from a consumer perspective and how the law protects them. Mm-hmm. I think a well-known case that showcases this comes from the case of the Ford Pinto, which is a landmark case in consumer protection because the company weighed consumer safety against profits and ultimately decided on profits. And through this case, the court found that, well, we couldn't have that and imposed criminal liability onto the company directors for this decision. I would say that's a pretty good example of how the public, from a consumer perspective, is at the very least protected from private interests by legislation. Okay. What do you think?
So the law, we don't think the law exclusively serves private interests, in my opinion. It does serve the public interest, but I would say that maybe in a more broader sense, or in a sort of class, economic class sense, that we can say that the law has, in more recent times, more generally served the interests of big business, for instance. I'd use the example of the recent corporate collapse, recession in the United States with the 2008 financial crisis and the ensuing corporate bailout to the tune of around $700 billion, which was a taxpayer expense. And now contrast that with the student loan bailout, which is, or the student loan debt held in the United States, which is $1.2 trillion. Now, there's no chance that that's ever going to be, they're going to pass a bill in Congress and bail out those students, but it was a priori that they were going to bail out the banks and the hedge funds, etc., in the United States. I think that, suggests that there's a very large influential lobby system in the United States and elsewhere in the West that serves interests of these big businesses, corporations, for instance. And as a result of this shift, we've seen massive social and economic inequality increasing exponentially since the 80s. What do you think, Manfred? Do you think the law serves public or private interests?
I think it's not an either or. I think, like you've said, that it looks at it does have to provide some consumer protection, otherwise it's just not going to work. However, with that example from the bailout, if the choice is between public and private in a more structural way, then it tends to, through the neoliberalism approach, favor the private interests of the corporations, as long as it's not hugely detrimental to the public. I think something has to be hugely detrimental to the public before something's going to come in to curb the free access that corporations have.
Yeah, exactly, and you're totally right, because that access basically comes down to the monetary influence, which is totally legal this day and age, to essentially just buy, legislators to do your bidding, isn't it? Now, moving on, the next question we ask is, who should the law serve? Now, I suggest that objectively, the law should clearly serve the people of the nation. Now, this is clearly stated in Australia's constitution, ostensibly the birth certificate of the nation, that the Commonwealth Parliament has the power to make laws on all subjects, including corporations. What do you think, Jason?
I agree that the law should serve the public as well, because, it's difficult to argue against the constitutional rights of the people. But I think in light of these corporate legal entities that have been created and the massive influence they have over the public, I think the law should be very careful by the means in which it aims to restrict private interests for the benefit of the public.
Mm-hmm. And Manfred?
I'd probably tend to agree, because although the law needs to look at both interests, if it has an adverse effect in its response that actually limits a novel public approach to some of the issues, ideally like with the sharing economy, if the regulation hampers free market access to the public that they wouldn't normally have, then it possibly is not going to serve any benefit it's not going to achieve the benefits it's trying to achieve. I do believe that we need to look at how the law can better serve the public interest, and that's possibly where we need to look at it now.
Yeah, exactly. Now, that was the third question. Now, clearly we think that neoliberalism has undermined this presumption that the law should serve the public, largely a result of 40 years of government and corporate PR. So now, in looking at this, how can the law change to better serve the public interest? We'll basically look at what we focused on in our essays to address this. Now, in my essay, I focused on historical examples basically from in the 30s to the 70s in the world. There was a general trend of progressive corporate governance. And in these Western countries, they adopted a more egalitarian and social democratic approach that sought to more equitably align the interests of business, the state, and workers to align these interests in a more egalitarian way. Now, in the US, this involved strengthening the power of labour. In the UK, it involved corporatism and public ownership, and in Australia it involved, to a large extent, industry protection, wage arbitration and state paternalism. More or less a form of socialism. What do you think, Jason? How did you approach this, whether the law should better serve the public?
I looked at it from the perspective of the fact that an imbalance exists, and that in solving it, one of the most straightforward ways is through the enactment of legislation. And I think we have two recent examples of how the government has tried to do this through the use of minimum wage to increase the income of individuals across the board, as well as carbon tax to produce a better living environment for the public. But I think these approaches are ultimately flawed, because companies are able to work around these restrictions, especially because...
So do you consider this regulation like soft or like...
I would consider these to be hard regulation, because especially in the case of carbon tax, where soft regulation has not worked, these rules have been put in place to penalize companies who have not followed the rules, such as fining them if they produce too much carbon emissions.
Yeah. So you're suggesting that hard regulation isn't effective as well, or in these situations it isn't?
While soft regulation can easily be overlooked, I mean, hard regulation is also it's not that it isn't effective. It isn't effective in the right way. It can create it can create an effect that the government is looking for, but ultimately this can come at the cost of public, the cost of public interest.
Okay, so you're wary about using hard regulation to get pro-social, outcomes basically when you're regulating companies.
It can backfire.
It can backfire.
Yeah.
Okay. Well, I think the hard regulation is a must. But what's your opinion, Jason? I mean, Manfred.
Look, I think the trouble with regulation is that often it's used by the existing dominant players in any industry to block new entrants to the industry.
Yep, exactly.
And we've seen that with the response from the hoteliers in the state of New York in response to Airbnb, where they really pressured the state government to pass legislation regarding illegal hotels. And while that seems like a appropriate piece of legislation, the timing of it, with that it came into being around 2010 when Airbnb started to actually have an impact, not because they were directly challenging the hotel industry, but they were providing a service that wasn't a viable alternative.
Yep.
And the industry then responded, brought in pressured the regulators, and brought in some regulation that made it very difficult for what the social connection that Airbnb was trying to achieve through its product, through its service, was now suddenly not allowed by the regulator. So the concern I have with the hard regulation is when I agree with hard regulation when it comes to something that's detrimental to society as a whole.
Yep. So environmental workers, etc.
Yeah, worker provision, slavery, healthcare, things like that. That makes sense. But when it's a regulation on the practice of conducting business, I think that's where it becomes a problem, because it limits the creative ability of society to come up with alternatives to directly challenge existing corporate structures. It doesn't require the law to do that, but the law, I think, needs to get out of the way so that if society is not happy with the way corporations are running, they can actually come up with an alternative without the law being used to negate the positive outcomes from new social movements.
Exactly, that's an important feature of capitalism, that it encourages innovation, experimentation, and I don't think people that go full socialist, they kind of, forget to look at, historical examples of, say, communism and just basically how state-run monopolies exclusively, they don't necessarily produce desirable outcomes either. The economy more or less stagnates.
I agree with the issue of having these large monopolies, because when you have something that controls such a big portion of a country's economy, it's very difficult for legislation to even affect it profit-wise, because they have many ways of working around these limitations, such as, going back to the examples of the minimum wage and the carbon tax, companies worked around this by retrenching workers, and even though their pay was increased, and especially for carbon tax, they made up for these lost profits by increasing the prices of energy. And I think this is quite a large issue in that the government is, to an extent, hamstrung by the fact that it is good for the country to have such large corporations, but in trying to restrict them, and this coupled with the fact that they are largely able to work around these restrictions, it's very difficult to control them to a large extent.
Yep, good. And as a final throwaway question, do we think that is the law powerless? Now, I mean this in a general, Marxian critique of capitalism, in that due to the increasing tendency of capital accumulation over time in the private hands of companies which have succeeded in promoting their interests, do we think as a consequence law is powerless to reform capitalism, or it is by nature unreformable?
I would say that to a certain extent law is not powerless, but when you're comparing public interest to private interest, the law is a bit hamstrung when it comes to restricting private interest, because a lot of these will ultimately trickle back into the public, and if the law's responsibility is to serve the public, that causes a major problem in what the law can do to restrict private interest.
Mm-hmm. And Manfred?
I would say that the law is not powerless when it comes to mitigating the negative effects of corporations, dominance and the profit imperative that comes from that. But I think it is appropriate for the law to remain powerless when it comes to the structuring of corporate entities and the way that business is conducted. You started out at the beginning, Harley, by saying that law created corporations. So how do you deal with that? And I think just bring the example back to Frankenstein's monster.
Yeah.
They created the monster, but then preventing the existence of another monster that might mitigate the negative effects.
Or do you have to create another monster to defeat the Frankenstein monster?
Or can you just allow another monster to come about that might produce a different result?
Yeah.
That's the question. So again, I think law should be powerful when it comes to the negative aspects, when it comes to environment, but I don't think law should be trying to reform corporations. I think that's for society and the economy to do as a whole.
Well, my final point is I would look at where we're headed generally, and if the tendency of capital accumulation is going to lead to greater monopolies, then you're essentially going to wind up with just basically Amazon running the world, don't you think? And what's the difference between that and just like full communism, where you've got one interest just distributing resources to everyone in the world? So I do think that you do have to ultimately reform corporations, whether it's under nationalisation or public ownership or something, just anything to bring about a more corporate social responsibility.